for joining us. My name is Katie Perez, and I'm a Senior Associate at Scott Legal PC. Today, we're going to spend some time talking about the L-1 and EB-1C visa requirements. Before we get started, some of you may know that our firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including an F1, a TN, a B, and an H1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics, and at the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded, and it will be available on YouTube. We will also send you a link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange for a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. So today I will present the first half of the webinar. My background includes 10 years of experience working at USCIS, where I did adjudicate the L petitions. We're also lucky to have our partner, Kelly Weiner, here to present. She'll present the last half of the webinar, and she has extensive experience processing the employment-based visas, including the Ls and the EB-1Cs. So let us get started. Okay. So what is the L visa? The L visa is a non-immigrant temporary work visa that allows the company to transfer certain qualified employees serving in a managerial, executive, or specialized knowledge role from one of their foreign offices to a related office here in the U.S. So there must be a qualifying relationship between the foreign and U.S. companies. That qualifying relationship can be that of a parent, subsidiary, affiliate, or a branch. And then the non-immigrant classifications for this visa are the L1A and then the L1B. So the L1 visa can be a good option for a company that's been doing business in the U.S. for an extended period of time, at least 1 year or more, and they want to send a qualified employee to the U.S. However, it can be an option for companies that have never done business in the U.S. but are looking to come here and expand their business. So companies who are just coming to the U.S., they would apply for what we call a new office. And then a new office is defined as an organization that's been doing business, operating in the U.S. Through one of those qualifying organizations for less than 1 year. So both the L1A and the L1B petitions can be classified as the new office. So we will go through the specific requirements for the L1A. So when an employer wishes to transfer an employee from the foreign company to the U.S. company as the L1 non-immigrant, they need to demonstrate in part that the companies have what we say was that qualifying relationship. So again, those relationships include a parent, subsidiary, branch, or affiliate. So here it is really important to look at the specific definitions in the immigration regulations for each type of relationship before you file your petition. So you would want to look at the definition and then the type of documents you have to support what type of relationship the companies have. Because the definitions are so specific, you might assume that the companies have one of those relationships like an affiliate, but in fact they don't meet the definition outlined in the immigration regulations. So as an example, oftentimes people say an affiliate is just companies that are associated. Maybe they have a shared, small shared percentage of ownership between two people. For example, so you might have company A that is owned by XYZ, and then you have a company, let's say Z, that's owned by X, Y, and K. So you have these companies that have two people that have owned part of the company. You can say they each own the same percentage of the companies, but in fact, they wouldn't meet the definition of affiliate because they're not owned by the same group of people. So it is really important to look at that qualifying relationship, because if you don't meet that definition and show there's a qualifying relationship, your petition wouldn't be approved. So something else you would have to do is show that the companies are both doing business. Doing business would be defined as conducting the regular, systematic, and continuous provision of goods and services. So you need to show that both companies are actively doing business. They're actively trading. So typical evidence for this, people often provide your taxes for the company. You can provide like audited financial statements. You can provide invoices, stuff like that would help to show that the companies are doing business. Um, there is no mandatory or regulatory minimum level of doing business activity that must be conducted to meet this eligibility requirement. But doing business really would be on a case by case basis. The officer will look at the type of business that you own or like the type of business you're conducting and the needs of the organization. So, if you own a business where you're selling goods, but you provide to the officer maybe invoices for January 2025 and August 2025, and you have low revenues or little to no employees, the government would likely question whether or not your company is actually doing business in accordance with regulations. So it is your burden to show that your business is doing business as regular. But again, you can consider the type of business that you have and the needs of the organization. So for doing business, um, the type or how long you've been doing business would impact the type of petition you're going to file. So we kind of touched upon this in the previous slide, but if you are coming to the U.S. to start a company and you've been doing business in the U.S. For less than 1 year, it would be, again, what we say is a new office. So with that L-1 new office petition, you'd be coming to the U.S. and then you have a year to get that business up and running to really do business in accordance with the regulations. So get the business up and running to do the regular, systematic, continuous provisions of goods and services. With that L-1 new office, you don't need to show regular business at the time you file. So again, you do have a year to get the business up and running. Another consideration for doing business requirement would be that maybe you've had a business here in the U.S. that's has a legal existence for more than 1 year, but it hasn't actually been doing the regular, systematic, continuous provision of goods or services. Um, so, for example, you have a business here you incorporated 2 years ago, but it's just been a passive entity. You might not have been doing much revenue or selling anything. So here, even though the business was incorporated 2 years ago, you could, and you plan to start trading, then you could file for that new office. And then last thing with the doing business requirement, just we like to emphasize that doing business doesn't include just the mere presence of an agent or office of the qualifying organization. So you really need to show that the business is active, is doing something. So you need to also show that the employee has 1 continuous year of full-time employment abroad with a qualifying organization within the 3 years preceding the filing of the petition. The employee's prior year of employment abroad must have been a position that was managerial, executive, or involved specialized knowledge. We do have very specific definitions for those types of roles for a manager, executive, specialized knowledge, and we'll discuss those just in a later slide. So you also, let's see, for the L1, so which is the manager executive roles, you can be approved for initial grant of 3 years. And then if you want to extend your stay, it can be extended in increments of 2 years for a total of 7 years. For the L1B specialized knowledge position, you can be approved again for initial grant of 3 years and then renew for increments of up to 2 years for a total of 5 years. With the L1 petition, you can also recapture time. So for example, if you have that L1 and each year you're here, you're actually spending time abroad a few weeks each year, then you can recapture the time you spend abroad. So again, you can spend a total of 7 years. And if you're spending a few weeks here and there each year outside, then it won't count against that 7 year clock. So it is helpful to keep track of your trips. While the government does have access to your travel records on occasion, they might not have the complete record, and then it would be your burden to show the government that you are eligible to recapture the time you're claiming. Okay, so we'll talk a little bit about the new office requirements. Again, the new office is an organization that's been doing business here in the U.S. Through a parent, branch, affiliate, or subsidiary for less than 1 year. And then there are a few additional requirements we'll talk about specifically here in the next slide. Okay, so for the new office, one requirement would be that you need to show that the company has secured a sufficient physical premise to house this new office. The physical premise really needs to make sense with the type of business you plan on conducting. So let's say you plan to do some sort of import-export business and you need a warehouse to house goods. Maybe you've told the government that you're going to hire 7 employees in that first year. If you're filing your petition for this L-1A new office and then you provide a lease agreement to the government, which shows, maybe you have a little shared office space with 100 square feet, it has one desk, no warehouse, then the government might say, you haven't satisfied this requirement. So if you're indicating in your business plan, you're doing this import-export business and you need to house goods, then they would likely say, okay, where are you going to house those goods? Little tiny office that's 100 square feet. And then if you've indicated that you're going to, you would need to explain where you're going to work. So if you conduct the need, how that are going to show the government fits with the needs of the business so that you can satisfy. Regarding the physical, this has become more malleable in more recent years. The government, they don't really spaces and you could receive pushback, but again, as long as you can demonstrate to the government that makes sense in light of the business you're going to conduct, this shouldn't be too much of a hurdle. So just at the time of filing the petition, you want to explain um, how the physical premise that you've secured makes sense with your business. If you're going to come to the U.S. under the L-1A new office to fill a managerial or executive capacity role, your qualifying role abroad should be a managerial or executive capacity role. So unlike other petitions, eligibility for the L-1A new office approval can't be established through qualifying experience involving specialized knowledge role. So if you are going to, with the new office, you don't need to have employees before you file the petition. So the focus of the new office would be really what you plan to do by the end of year 1. So you would want to explain to the government how many employees you want to hire, what roles they will fulfill, that sort of thing. So you want to show that by the end of year 1, this new office will be able to support a managerial or executive role, which would be for the beneficiary applying. So again, you don't need to have employees at the time you file the petition. Because you have 1 year to kind of hire them, get the business up and running. If you do have employees at the time you file, that's fine. It can help support that this new office will in fact support a managerial or executive role. Other ways other things the government will focus on to see if this new office will in fact support a managerial or executive role would be just the scope of the business, the organizational structure, the financial goals of the company, your hiring plan, and then just you would want to explain how you're going to accomplish all these goals so that the business really will be successful and it will support a managerial or executive role within 1 year. So the government will they'll also look at the size of the U.S. investment and the financial ability of the foreign company to pay the employee to start doing business here in the U.S. You would want to show, or explain if the foreign company will capitalize the U.S. company, where's the money coming from. So with new offices, sometimes you will get the government to look at the financial needs of this new organization. And sometimes they will say that the foreign company should be able to capitalize the total expenses. However, that's not in the regulations, so you can push back on this, but they do just want to see, that the foreign company is solvent. There are funds um, that this new office really can be successful. So if you do have a foreign company and you have negative bank balances, that sort of thing, that would be a red flag for the government. So let's see. So another consideration the government will look at is will the foreign organization provide personnel support to the U.S. company? Um, that would be something you would want to explain. Just really, you want to give this big picture of how this new office will be successful. So maybe you do have employees abroad who will support this U.S. company. So, for example, maybe you don't have plans to hire any administrative support, but the foreign company has this administrative support that can support the U.S. company. You would be able to explain that to the U.S. government in your petition. Um, so it is understood for this managerial or executive role for this new office that you're coming to open this new business and you will be more involved with the day-to-day operations during those initial phases, but the government would want to see, that you will eventually, within that 1 year, be performing more high-level duties. That you would have staff there to relieve you from performing those administrative and operational duties of the business. Okay, so let's go. So for the go to the next one. For the L-1B new office petition, this would be for someone who has served in a specialized knowledge role abroad, and then that person is going to come to the U.S. company to also perform specialized knowledge duties. So for the requirements for this one with the L-1B new office, you would want to show that the foreign position and the U.S. position involve specialized knowledge. Um, you need to show that the employee has that specialized knowledge. You'd also still need to show that you have secured that sufficient physical premise. And then you need to show that the petitioner has the financial ability to remunerate the employee and then commence doing business here in the U.S. Okay, so again, I stated earlier that there are specific definitions within the regulations for executive, manager, and specialized knowledge. So specifically for executive capacity, this means that the person will primarily direct the management of the organization or major component or function of the organization. That person will establish the goals and policies of the organization, component, or function. They will have the ability to in discretionary decision making, and then receive only general supervision or direction from higher level executives, the board of directors, stockholders, that sort of thing. To demonstrate executive capacity, you would really want to show that this person will perform high level responsibilities. You also want to show that the person will be primarily engaged in those executive duties as opposed to the normal operational tasks, administrative tasks of the business. That would be performed by, other employees. You would really want to detail the beneficiary's duties, explaining what they will do on a daily basis. You want to provide a percentage of time with those duties so that the government or the officer reviewing the petition would be able to determine that the duties are primarily executive. So when you are describing the role of someone who you are claiming to be an executive, you do really want to describe the role in a manner that does line up with the definition that we just went over. As an example, so if you are claiming the person will perform as an executive, the regulations state that the executive would direct the management of the organization. So an executive directs the management of an organization by controlling the work of other managers or other executives. So this can be like direct supervision or indirect in some cases, but the key to this part would be that you need to show that there are, in fact, other managers for you to direct or oversee. So if you're submitting an organizational chart where you're planning to directly oversee the people that will be performing the operational tasks of the business, that the government would question whether or not you have managers to direct. So you would likely not be meeting your burden. Um, so generally, with someone claiming an executive, you would have a multi-tiered organization. Um, that doesn't, there are ways around this. It doesn't have to be one way to file, but again, you really would need to show that you are meeting the definition of executive. So other ways to help show that you would be able to meet the definition of an executive would be to provide a detailed organizational chart, provide detailed duties for your subordinates, and really explain to the government who is there to support you and how they will support you so that you will be able to focus on the high level duties of the organization, like establishing the policies and the goals of the organization. Just with the executive, a few more things to focus on. Having that executive title alone won't be sufficient. So a lot of times people think just because, I am the owner of a business, I'm in charge, I do establish the policies, I do hire and fire people, but maybe, you only oversee two people within the organization. It's a small structure, and you are in fact performing a lot of operational duties. Despite your title of CEO, that wouldn't be sufficient to meet the definition of executive. So it's not about the job title. It is really a focus on the duties, what you will be doing on a daily basis, and how often. So you really need to show that the structure will be there to support your role as an executive. Just lastly, if you aren't able to show that the structure is there or people are there to support your role as an executive, maybe you would want to choose a different category like a manager or a specialized knowledge role. Okay, so we are going to switch over to our partner, Kelly. She's going to continue with the definitions for a managerial capacity. Let's see.
Thank you, Katie. All right, so let's talk about the definition of managerial capacity. As Katie has outlined, there is a very specific definition for each, category under the L-1. So even if, there's many people whose job title includes the words manager, that doesn't automatically mean that they are going to be qualified as a manager under this regulatory definition. So you do need to look at it in detail. A manager is somebody who manages an organization, department, subdivision, function, or component of an organization, supervises and controls the work of supervisory, professional, or managerial employees, or manages an essential function, has authority to hire and fire and recommend other personnel actions, or if managing a function, functions at a senior level within the hierarchy of the organization, and exercises discretion over day-to-day operations. The regulations also specify that a first-line supervisor will not be considered to be acting in a managerial capacity unless the people that they supervise are themselves supervisors or professionals. And so there's two types of kind of people that can meet the managerial capacity requirement. One would be a personnel manager. So that's people that are directly responsible for managing other managers or professionals, meaning people whose jobs require bachelor's degrees or higher. And the other would be a function manager. And a function manager may not have any direct reports of their own, but may manage a particular function and perhaps have indirect reports within the company structure that actually performs the work of the function, whereas the manager oversees it. So if it is the type of situation where you yourself don't have direct reports, but you do kind of manage a particular function and have people in other departments with other direct reporting lines who are doing that work, that can be another good option in that scenario. Can go to the next slide. Perfect. So, what is specialized knowledge? So, specialized knowledge means special knowledge possessed by an individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interest, and its application in international markets, or an advanced level of knowledge or expertise in the organization's processes and procedures. So, in either circumstance, you need to demonstrate that the person has knowledge not commonly held throughout the industry. So this is the L-1B option. So sometimes people think, well, if it can't be an executive or manager, I can qualify as a specialist. And this can be one of the more challenging categories to meet the requirements for because you do need to provide a lot of background documentation to show that you do have this specialized knowledge. It doesn't always have to be kind of proprietary, secret knowledge that you have, but it does help if the person does have that knowledge. So, you do need to also be prepared to do a comparison of that person's knowledge as compared to other people within the company and the industry. So, if you have 10 other people that do exactly what this person does and there's really no difference in their jobs, that's not a good, kind of option for a specialized knowledge L1. Um, a few things to consider, so if the person maybe doesn't have, decades and decades of experience, that would make it easy to prove that they have this special knowledge, that's not common throughout the industry. You could also consider, does this person have specific advanced knowledge of the particular company and its organization's processes and procedures? So, for example, if somebody was hired when a company was very small and was kind of scaling, and then the company scaled very rapidly, and that employee had a big hand in developing the foundational processes and procedures that help to run the company now, that can be kind of a way to, kind of get an L1B for an applicant who maybe doesn't have decades of experience, but perhaps has very specific experience, with this particular company and has had a hand in kind of building that company from the ground up. And that can work as well in this category. All right, so let's talk about when you're doing an L1 application, what documents need to be submitted. So you need to submit U.S. Citizenship and Immigration Services Form I-129 and the L supplement. If you have an attorney, you'll also submit a G28. If there's a premium processing request, you'll also submit a form called an I-907. And then you need to provide documents that show you meet each of the criteria that we've kind of talked about here. So one, corporate document showing that there's a qualifying relationship between the companies, parent, subsidiary, branch, affiliate, proof that each company is doing business, or if it's a new office, that the US company is preparing to do business. So these are going to be things like company tax returns, audited financial statements, lease agreements, payroll summaries, client contracts, anything that shows that the business is actively running. If it's a business that is very high profile, is in the media a lot, and doesn't want to share their financials, you may be able to submit more supplementary material showing media coverage of the business, as opposed to the specific, tax returns or things like that. Then you need to provide proof that the employee has worked abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. So you're going to show, pay stubs, detailed job descriptions, organizational charts showing the employee hierarchy, work product. This is particularly important for kind of specialized knowledge petitions to show that the work that you're doing actually does require specialized knowledge. That work product should also include, kind of explanations for what the work product is, as opposed to just providing, here's a bunch of emails. You want to really kind of be specific about what this work product is showing, how it shows they meet the criteria. You also have to provide proof that the employee's role in the US will qualify as managerial, executive, or specialized knowledge, and you're going to provide similar documentation, perhaps memos explaining why this person was selected for transfer and what's necessary about their role in the US. The jobs do not need to be the same. So if somebody was kind of a specialist, abroad and they're being transferred to, serve as a manager, that's fine. But you do need to show on each side that they meet the regulatory, criteria. And if it's a job that they are not currently doing, you also need to provide evidence that they have the skills and ability, experience, and training, to do that job in the United States. All right. So, what do you need for a request for evidence? So, request for evidence kind of went through, go through kind of phases. There was a period in time where RFE rates were extremely high, over 50% between 2019 and 2021. Data from 2022 to 2025, I know that's not on here, show that RFE rates have kind of dropped to between, the 20s to 30s, which is a big improvement over the 50s. That being said, it is quite common to get requests for evidence for L1s. Often they will challenge, even if they're challenging other aspects, they will often always challenge the managerial executive and specialized knowledge worker aspect of things. So they often will ask for more information, say that the job duties are too generic. So you do want to be as specific as you can. You want to provide examples. You don't want to use a lot of kind of acronyms or buzzwords that are unclear. You really want to make sure that somebody who doesn't work in your industry could read this letter, understand what you do, and understand why it correlates with the regulatory criteria. Detailed support letters, organizational charts with details about employees, particularly for managers, or executives, where you're showing there's that hierarchy in place. And then it's very important in RFE. If they ask about this, you want to supplement any of these letters and organizational charts with objective evidence to show that the statements that you're making, are kind of supported with work product, with payroll summaries, with kind of official documents within the company. So it's not just kind of a letter provided by the employer that says, yes, this is what happens. You really want to supplement that and show, here's emails with the person regularly meeting with the CEO. Here's kind of the times when the manager approved, leave and promotion and end of year kind of reviews for the employees that they manage. And here's the proof that the employees are professionals or supervisors themselves. So you do want to supplement with that objective evidence. All right, so let's talk about timing and dependence. So the L-1 petition, the process is that the petition first has to be approved by U.S. Citizenship and Immigration Services. Processing times are generally several months, but you can pay an additional fee to get a response within 15 business days. That can be an approval, a denial, a request for evidence, a notice of intent to deny. If it's an approval, then the employee applicant can go schedule an appointment at a U.S. consulate to get their L visa stamp. If it's a request for evidence, you'll generally be given around 87 days to submit a response. If it's a notice of intent to deny, you'll be given 30 days to submit a response, and then you'll generally get your final response 15 business days after they receive, the additional documentation. One caveat to this process, or two caveats. One is for Canadian applicants. So Canadians for their first L1 can apply at the border. So that means they're going, to a port of entry and speaking with, a consular officer. I'm sorry, not a consular officer, a Customs and Border Protection officer, who then, will approve, put an L stamp in their passport, and then the petition is sent to U.S. Citizenship and Immigration Services for final processing, and they will also issue an approval notice after that. Um, the other caveat is for kind of blanket L petitions, which we're not really discussing here today, but that's for companies that are generally extremely large, doing kind of, thousands of L1 applications, or, have a, business over a certain, amount. And for those situations, the companies have kind of what's called a blanket L certification, and the employees are themselves going directly to the consulate with proof of that certification and, other documentation, and then the application is adjudicated, at the consulate. So for dependents, if you can bring your spouse and any unmarried children under 21. They can accompany you on L2 dependent visas. L2 spouses can work. They no longer need to apply for employment authorization cards. They can work based solely on the spousal annotation on their I-94. So after you enter, you always want to check and make sure it says L2S. That's what permits you to work in the United States. Children on L2 status cannot work, but they can attend school. The other thing to consider about the process is if you're already in the United States on a status that allows you to change status, for example, you're already in the US on perhaps a B1 visa, you could change your status, to L1, or if you're here already on an L1, you can extend your L1 status through USCIS with an extension, as opposed to having to, get the approval through consular notification and going to the consulate first. That being said, for first-time L1s, because they are working for this company abroad, often they are, going the process of getting the USCIS approval and then going to the consulate. All right. So does an L1 visa lead to a green card? This is a very common question. And For L-1A, visa holders who were managers or executives at their foreign company, the EB-1C can be a good option. This is a multinational manager or executive green card category. It has very similar requirements to the L-1, but there is a heightened standard. So if you got your L-1A, but it was a tough fight, like you really had to provide a lot of extra documentation. It was difficult to get the L1A approved. That those same issues may come up at the EB1C stage. So the fact that you have an L1A approval does not mean you're automatically kind of rubber stamped for the EB1C. They will want to see this qualifying relationship between the company abroad and the US company. Both companies have to have been doing business, and the US company has to have been doing business for at least 1 year. So there's not kind of that new office option that they have for the L. The employee has to have worked in an executive or managerial role. And no labor certification is required. So the EB1C can be a great green card category because you can file the I-140 petition. And then if your category is current, you can file your adjustment of status or your green card case for consular processing. And it's often current, in this particular category, and you're not having to wait, the several, years for the labor certification process. One thing to consider is that if you were a specialized knowledge worker abroad and you're coming over, as an executive or manager, you cannot use the EB1C because you need to have been an executive or manager during that year abroad. Additionally, if you had a very, very small company while you were working in that executive or managerial role abroad, years later, even if the foreign company has grown very large, that doesn't really help necessarily because they will look back at the time that you spent working. And so if the company had 3 employees at that time and now it has 100, not to say that's not valuable for other aspects of the case, but they will look back at the time that you were actually working there. And you will have to convince them, yes, I was, an executive or manager, even though we had such a small company. So when you're thinking strategically about this, you do want to think not just, how will the company grow in the US or grow once I'm in the US? You need to think about, how will I prove I meet the criteria for executive or manager, before I transfer to the US. Um, for the L1B, specialized knowledge workers, the EB1C is not available. These applicants could go through something called the PERM process. This is where the US company will sponsor them for a green card. They'll test the US labor market for any willing, qualified, and available US workers. If there are none found during the labor market test, then the company can file a labor certification with the Department of Labor. The perm process is a viable one, but also one that takes quite a long time. So if you're coming on an L1B and you know you want to get a green card, you want to talk to your employer early on about the green card process because it can take several years. And there will come a point where, it's not possible to kind of extend the L1B anymore. So you want to plan ahead because even just the first part of the perm process with getting a prevailing wage, doing the labor market test and waiting for the labor certification, that in itself can be almost 2 years. And then there are, periodically backlogs in the EB2 and EB3 category, particularly if you're born in India, or China. So you do want to plan ahead, if you're going through the perm process. All right. So we've reached the end of the presentation. And if there are any questions, you can type them in the chat box. I don't see any typed in at this point. All right. So I think we will close here. Katie, thank you very much for sharing your knowledge. Thank you, everyone, for joining. I hope everyone has a wonderful day. Thank you.
Thank you.